We're going to begin now. In this session, we're going to consider the policy implications of a research project, written by Professor Joanna Shepherd-Daly from Bailey, I said Bailey, from Emory Law School. And this morning, it was empirical research, and I'm going to just give you a quick summary of it, but this morning we had 2 roundtables talking about that research and what it showed and what future research might be done. This afternoon, we're going to talk about the policy implications of that study. In brief, what that study showed, what that study looked at was state Supreme Court decisions. It looked at campaign contributions from a variety of interest groups, but in particular from business interest groups in elections, regardless of whether they were retention, nonpartisan, or partisan elections. And what they found was that there is a statistically significant correlation between contributions to candidates who are running for the Supreme Court in those elections and the votes of those who were elected, and the later votes of those who were elected, and the votes with regard to business cases. The concerns that quite readily arise from that are whether the campaign contributions have an actual influence on the decision-making of Supreme Court justices. There was also an implication as to whether there's a perception by the public whether those contributions affect and influence the decisions of those Supreme Court justices. For our purposes here, what I'd like to do is I'd like to frame and focus first on actual influence, and I would like to bring that to a focus on self-interest. Actual influence, the implication might be, is that the money can actually influence the judge by creating a self-interest in that judge, a self-interest in getting elected or getting re-elected to the bench, and therefore the judge would have a self-interest as a result of the campaign contributions. It might be to serve well those who supported in the past, and it might be to ensure future support in the next election. It also has an implication of systemic bias. That is, does money in the campaign influence voters in such a way that they then cast votes consistent with the interests of those who are providing the money, and thus those voters elect people who have an inherent partiality, and therefore the overall balance and partiality of the court changes, not necessarily because the judge has been influenced, but because the system has been influenced by those contributions. And then the other issue is the perception of influence. Studies have shown that the public does see, does believe, does perceive that campaign contributions influence judges' voting behavior. And so that's the way we're going to focus the discussion here this afternoon. As we discuss it, what I'm going to do, we're going to start at the end of the process. Rather than starting at the beginning as to the election process, we're going to go to the end of the process and talk to the judges and the attorneys who have been involved in judicial decision-making and have perspectives on judicial decision-making. Then from there, we're going to go back to the beginning, and we're going to talk about the election process step by step. The method of election, the method of campaign contributions, the disclosure of campaign contributions, the disqualification as a result of the campaign contributions. We have a distinguished panel here today. Before I introduce the panel, I just want to briefly introduce two Vanderbilt Law School 3Ls who helped me in getting prepared for this. So we have Amanda Wynn and Sunny Yu, and thank you very much for your help. And now I'd like to introduce, first on my left in the middle, Senior Judge Martha Daughtry. of the United States Court of Appeals for the Sixth Circuit. Each of these panelists have incredible credentials, and I'm not going to go through the entire litany. I'm just going to give you some of the highlights, and especially as we sit here at Vanderbilt. Judge Daughtry got her bachelor's degree and her Juris Doctor here at Vanderbilt. She was an associate judge of the Tennessee Court of Criminal Appeals. She was an associate justice of the Tennessee Supreme Court. And then she has been, or was, a Sixth Circuit Court of Appeals judge beginning in 1993. She went to senior status 5 years ago. To her left is Judge Randy Smith from the Ninth Circuit. Judge Smith resides in Idaho and has been kind enough and generous enough to come all the way across the country to be with us here. His bachelor's degree is from Brigham Young University. His Juris Doctor also from Brigham Young. He also sat as a state court judge. He was a trial court judge for the 6th Judicial District of Idaho, and in 2007 became a judge of the United States Court of Appeals for the Ninth Circuit. On my left also is Tommy Wells. Tommy Wells is an attorney with Maynard, Cooper, and Gale in Alabama. He is a former president of the American Bar Association. He got his bachelor's and Juris Doctor's degree from the University of Alabama. He is a member of the American Law Institute. He's a fellow of the International Academy of Trial Lawyers, and he is listed as the best among the best lawyers in America for just about anything you are interested in. To my right, at the far right, is Alicia Bannon from the Brennan Center at New York University. Alicia is an undergraduate, has an undergraduate degree from Harvard and a law degree from Yale. She has, early in her career, very much interested in Africa and children's rights and family rights in Africa, and in the Center for Global Development and in a refugee clinic, as well as children and their societies. She later became a clerk first for Kimball Wood in the Southern District of New York, and later for Sonia Sotomayor when she was on the bench of the United States Court of Appeals for the Second Circuit. In the middle is Professor Charles Jay. Professor Jay is the John F. Kimberling Chair in Law, and he is Associate Dean for Research at the University of Indiana Maurer School of Law. He has his undergraduate and graduate degrees from Wisconsin. He was a law clerk for the U.S. Court of Appeals 11th Circuit, Judge Thomas Clark. He also served in private practice. He was also counsel to the United States House of Representatives Judiciary Committee. He's been special counsel to the administrative offices of the U.S. courts. He's been on the faculty at American University, Widener University, and now at Indiana. Next to my right is Professor Chara Torres-Spelisi from Stetson University Law School. She has her undergraduate degree from Harvard and her graduate degree from Columbia. Before joining Stetson's faculty, she was counsel in the democracy program of the Brennan Center for Justice at NYU, where she provided guidance on the issues of money in politics and the judiciary to state, money in politics to the judiciary and state and federal lawmakers as well. She was an associate at Arnold Porter, and she was a staffer for Senator Richard Durbin. Having read all of these, I wonder what I'm doing here. I am Russell Carperelli. I am the Executive Director of the American Judicature Society. Before coming, I just joined the Judicature Society at the first of the year. Before that, I was a judge on the Colorado Court of Appeals for several years. And before that, I was in private practice, and before that, I was judge advocate in the United States Air Force. What I'd like to do is to ask about the practical experiences of the judges. And so, Judge Doherty, Judge Smith, you've participated in judicial elections, you've participated in judicial appointment, and you've sat with your colleagues who have done so. When you've sat with your colleagues and made judicial determinations, what's your experience as to how they are influenced or not so influenced by the appointment process or by the elected process? Judge Daughtry?
Well, I don't know Russ if I'm the best person to start off, simply because nobody's ever complained they couldn't hear me. Because I came up through the political system. The time that I ran for office was for the Tennessee Supreme Court at a time when it was being filled on the basis of partisan elections, open elections. As was mentioned over there just a few minutes ago, we ended up that year without any Republican opponents, but we were running on a partisan ticket. There was an interesting sort of aside about the campaign contributions, because we didn't know that the Republicans weren't going to run a slate. So at some point it occurred to us we needed a little money. We were on a tour that took us around to the county seats of all the counties in Tennessee. It turns out they're 95, and we made it to 66, which I think is a pretty good record, in a little van with volunteer drivers. And ultimately, we raised about $50,000 and through a committee. Now, frankly, $50,000 even in 1990 isn't going to buy much for anybody, truthfully. The thing that worried us was, I mean, who was really interested in our election or in, you know, any judicial election? And the answer is the lawyers. And so you end up trying to get money from the lawyers that are going to be actually appearing before you, which is a very uncomfortable position to be in. And so we had a committee that was doing the money raising, and we took the position that we didn't want to know who gave what. The problem was there was a financial contribution disclosure law in Tennessee that said that everybody who raised money running for political office had to sign a statement where the contributors were listed and how much they gave was on there. And we were supposed to sign it as being correct. And so we were kind of hoist on our own petard at that point. I have to admit, I don't remember what we did. As I get older, the memory gets fuzzier, but it was, I will say, in my defense, almost 25 years ago. So I think the statute of limitations has run on my need to do it. So it was a pretty benign situation here in Tennessee then. Now, those of you that have been over here now know that it's not going to be so benign around here much longer, regardless of whether it's an open election or not. And I have to say that I will give you an example in closing. There was a time, and I wouldn't want to say exactly when it was, but there was a time when the Texas Supreme Court, which, by the way, handles only civil cases. There's also a Texas Court of Criminal Appeals that is the Supreme Court of Texas as far as criminal cases are concerned. So here was a state Supreme Court that was completely oriented into civil appellate litigation. And eventually, because of contributions, the entire court, there was always a fight between the plaintiffs' lawyers groups and the Chamber of Commerce and the insurance defense bar and the insurance companies and so forth. And eventually what happened was the entire court was made up of those on the corporate insurance company side. And it was known throughout the country that it had been done deliberately, and that in fact the money interests had succeeded in doing that. I wish one of our smart political scientists could go back now and look at those decisions, because I think I know what they would show. Up till now we haven't had a problem in Tennessee, but we're on thin ice, I think, at this point.
Judge, you've made a statement that I think is obvious to everybody, but I'm going to ask you to be explicit. You said you didn't want to know who gave the money. Why?
Well, I think the main point is, I mean, I'm not going to vote in their favor because they've given $50 or $100. But the fear out there is that I would be influenced by that. I mean, we're talking about the perception from the other side of the bench, frankly. And not just that I might vote in favor of those who gave the money, but more importantly, whose name is not on the list, and that the lawyers coming before me who have not supported me might not get a fair break in court. So I had no concern about myself, but there is this perception of impartiality that we're supposed to be dedicated to, and that for the most part we are dedicated to. And that I would have wanted to be able to say, I'm not in a position to decide a case based on who your lawyer is and whether that lawyer gave a contribution or not.
Judge Smith?
I would echo, I think, what Honorable Daria said. The actual bias that is shown, at least in my experience, I think is negligible. Because I really believe that in most situations, one gets there and one does what one thinks is the best thing to do. My worry, I guess, is the perception, but let me just talk a little bit about the actual. I think that when you get to the bench, you really truly do believe that the canons mean something, and you work hard to make sure that that's what is done. And I think that therefore the actual change that you might make is negligible. My worry is the perception that she just talked about. I've been through many times of where I've been on certain panels or as a district judge, and frankly, I never knew who gave me something or who didn't, but it was always a bother to me that somebody may perceive that I was going to act one way or another. I remember I was an insurance defense lawyer before I took the trial bench. Well, given that I was an insurance defense lawyer, those who, when I got to the bench, there were lawyers, I'm sure, were on the plaintiff's bar who thought I was on the dole from the insurance companies, who were a little bit worried about what I was going to be like. I made an avid, if you will, an avid effort to make sure that I did the right things in the right times, and that there was not even though it would have been the insurance industry who would have probably backed my campaign, that I was going to make sure that I did not favor one over the other. So the actual, and I saw others do the same, it seemed to me that one was more taken by what one had done prior to getting there. Plaintiffs' lawyers were generally perceived as those who would help the plaintiffs, and defense lawyers as those who would help the defendants, and therefore that was the if you will, the situation we wanted to avoid. The perception is more the worry that I have, and the perception is the one that I feel like you have to worry about more than ever. And therefore, if I had to talk about perception, that's where I had. And I went to bat, frankly, for the idea that no one would know who gave money to whom in Idaho elections when I was an elected judge. It just so happened you could find it if you really wanted to, but I went to bat that we had a disclosure of who gave to who, but the judges were not supposed to see who did that. But it is that perception that I worry about.
Let me ask both of you again. This morning at the second roundtable discussion, there was a comment that as elections approached, sentences got more harsh. And that would be both, I guess, at the trial court level and perhaps on review at the appellate court level. Do you have any experience with that?
Yes. And it comes from the years I spent on the Court of Criminal Appeals looking at criminal cases only. Back in those days, we actually had interesting questions in front of us. It's down to sentencing now. But yes, the problem is in Tennessee that every judge is elected for an 8-year term on the same day every 8 years. There's no staggered elections. And so what you would begin to see as election time came up would be not just the harsher sentences, but the rulings in court began to get tougher, and the appeals. Actually, some of the rulings were so tough that they ended up being reversed because they really were not fair or not in compliance with law. But it was clear to me, I wouldn't call names at all, but it was clear to me there was some get tough on crime thing behind that election period that was coming up.
Judge Smith?
Well, I don't know that the trial judges did that quite so much, but there were really not very many, if you will, tough elections for trial judges. But it was interesting to me. I'm not being accusatory, but it was nonetheless interesting to me that in a state where we had elections, that there was never a death penalty which was reversed.
Mm-hmm.
That was a worry. And it still is a worry, to be fair. I mean, it seemed to me that was, I mean, there were a lot of reversals in drug crimes and a lot of reversals in robberies, but never a death penalty reversal,
Now,
which was a nervousness to me.
now the topic here today is primarily about money in judicial elections. Do you think money had anything to do with either of those?
Well, I see this just a little bit differently. It seems to me that money goes where you think your candidate's going to go with you. I don't know that people were necessarily influenced, but I know the money would go to the opposition candidate in situations where you thought the candidate was going to rule opposite of where you thought they ought to go. I don't know that it was necessarily meant to influence them in so much as you knew the money was coming, you're going to have to campaign again, and there you're going to be. Now, I'm not accusatory, I'm just saying it was an interesting fact that we never had one of those happen.
Do you have an intermediate court?
We do.
Yeah.
So Tommy, you practiced your entire career in Alabama. All the judges in Alabama are elected, and both in your role as advocate for your clients, but also as a member of the bar in your discussions with other lawyers. What's the perception there as to the extent to which the election process and the money in the election process influences outcomes?
Well, I think the perception is pretty uniform. The perception is, yes, it influences outcomes, and that's why money comes in. I mean, why would people from out of state pour money into an Alabama Supreme Court race unless they thought it was going to affect an outcome somewhere? Maybe not a specific case, but an outcome. You know, let me give you a slightly different example. There is an open seat on the 10th Judicial Circuit, which happens to be in Birmingham. I am on the campaign committee of 2 Democrats and 1 Republican that are running for that seat. One of those 3 is going to win. And one of those 3 is going to see my name in the paper as part of his campaign committee who gave him money, or her money. Does that influence the judge? I don't think so. But, you know, in the back of my mind, I worry about what you said, that if they don't see my name on the list and they see my opponent's name on the list, you know, what kind of shake am I going to get in that court? You know, in one way, it's a perfect, you know, it's a perfect excuse to give a client if you lose. Well, you know, I just didn't give to you.
Yeah.
But interestingly enough, I think it's the perception, but very little of the reality. In my entire career, I think I have only asked 1 trial court judge to recuse himself. That was for the probably specious reasoning that my opponent was representing him in his indictment over felony election fraud. He didn't want to recuse himself. He ended up not recusing himself, very specifically in an opinion that said he could be fair and he wasn't going to recuse himself, but he was reassigning the case to another judge. So, you know, I sort of got what I wanted from that one. So, you know, I think some of it harkens back to the presiding judge in Birmingham that just retired is Judge Bowell. Judge Bowell had been elected time after time after time. Since he has gone off the bench, he has become a vocal opponent of judicial elections because he just felt like it was unseemly to go out and to force a judge to go to lawyers who were going to appear before him or her and ask them for campaign contributions. Because, you know, who's going to give? And here I think there's a distinction between the civil bench and the criminal bench in elective states. I mean, on the criminal bench, nobody gives to the judge because the prosecutors don't have any money, and the criminal defense lawyers are not going to give because they're criminal defense lawyers, and you know 9 times out of 10 they're going to lose. So you know there's very little money spent on criminal if you're assigned to a criminal case. On the civil side, it is can you bar the door. There's money flowing in, you know, 8 ways to Sunday. Interestingly enough, Alabama is one of the few states that actually has a statute on the books that says if a lawyer who is appearing before a trial judge has given $1,000 or more to that judge's campaign, the judge should recuse himself or herself. And for an appellate judge, it's $2,000. That's been on the books since the mid-90s. The statute was written to instruct the Supreme Court to write rules to implement the statute. It's now 2014 and the Supreme Court has not quite gotten around to writing any of the rules because they didn't want to. But you know, that shows at least a benchmark. Yeah, that showed at least in 1996, the Alabama legislature believed that at least there was an appearance of influence at those particular campaign levels. You know, I don't think that's a magic number. You know, $1,000 in a race in New Hampshire is probably a lot of money. $1,000 in a race in Arizona or California is nothing. But it's bothersome. And when you get to the Supreme Court level, the Supreme Court, of course, handles both civil and criminal appeals. We have intermediate civil appeals courts and criminal appeal courts, but there are some cases that have to go to the Supreme Court. And any significant civil case has to have Supreme Court review. And that historically is where the really big money, I'm talking millions of dollars, has come in. We had an election a few years ago, if you counted the money raised in the primary, I think it was like $7.2 million was raised in a race for an office that pays, you know, $165,000. That's not a good return on investment. I'm no economist, but you know, I don't get the return on investment there. And I think it creates other issues too. You were saying back when you were running as a Democrat and the Republicans didn't put up any opposition.
At the last minute.
At the last minute, yeah. We had a situation in Alabama in the last election for Supreme Court where the Democrats didn't really want to put up a candidate, but a candidate qualified. And to put it mildly, he was a raving lunatic. He went around the state talking about how he would rule on specific on issues. He said he would never vote for gay marriage. He was, you know, there were crazy things he was saying. Finally, the Democrats took his nomination away and had the executive committee put a sitting trial court judge in his place who was a very credible candidate. But he ended up losing to now Chief Justice Roy Moore, who famously was removed by the Alabama Judicial Inquiry Commission the last time he was Chief Justice for refusing to obey a federal court order to remove his massive Ten Commandments monument from the Alabama State House.
So Tommy, your comment about the $7 million then really gives us an opportunity to go back and here to talk about the beginning of the process. So the first question is, we have elections. I'm sure there's people who feel that elections are good or bad, or is there anything good about elections? I mean, why should we have elections? Alicia, is there anything good about elections?
Sure. Well, I mean, I think if you look back historically to why many states turned to judicial elections, I mean, I think there was there was a concern that, you know, other forms of judicial selection were insufficiently transparent, that they reflected, you know, sort of backroom negotiations, you know, perhaps concerns even about corruption in those processes. And so, you know, the advent of judicial elections was seen as a reform effort to bring a sort of accountability, popular accountability that was not existing in the more traditional appointment system. So I think that was the motivation behind the introduction of judicial elections. You know, I think that, among other things, you know, judicial elections could be an opportunity to educate the public about what the courts are. They're a very public moment. So I mean, I think there could be good opportunities to have conversations about what the role of the court is. I think one of the concerns that we're seeing in today's environment is that judicial elections may not be serving that role. So among other things, I work at the Brennan Center for Justice, and one of the things we do is track state Supreme Court races, and we put out a report along with Justice at Stake and the National Institute on Money and State Politics, basically looking at what's happened in a particular election cycle. And a lot of what we've been seeing in these recent election cycles is deeply troubling. I mean, especially since about 2000, we've been seeing, you know, huge amounts of money pouring into these elections, largely from special interest groups. You know, in the most recent 2011 to 2012 cycle, it was about $56.4 million were spent nationwide. More than half of the contributions to judicial candidates were coming from lawyers, lobbyists, and business interests, so exactly some of the people who are appearing before the judges that are running for election. We've also been seeing, you know, this most recent election cycle, kind of a Citizens United effect, where we've seen a real rise in independent expenditures, so special interest groups and political parties, rather than contributing to candidates, spending directly to elect candidates, and that's bringing with it a whole new set of problems. Among other things, television advertisements from independent groups or political parties tend to be much more negative. There's also, there's typically even less transparency about where that money is coming from. So I think that's opening up, you know, additional cans of worms. And another aspect of elections that we've been tracking that I think is particularly troubling is the rise of negative and misleading advertisements. So we've looked at television advertisements in state Supreme Court races. In 2011, 2012, there were at least 10 states that had some form of attack ad, and many of these ads were doozies. We had judges accused of expressing sympathy for rapists, you know, distorting a statement that a judge made during sentencing, and you know, and that ad continued despite the State Bar Association stating that it was misleading and calling on the party that had sponsored the ad to pull it. You had judges accused of sympathizing with child molesters, expressing sympathy for terrorists. I mean, there's a lot of noise, a lot of misrepresentation of people's records. And you know, I think one of the overall challenges with judicial elections is that there's not a lot of public information about these judicial candidates. And so when you start with very low information races and you add misleading information about judicial candidates, I think you're left with the question of can those races really be serving the accountability function that I think was the initial impetus for many states moving towards judicial elections.
So we started with a perception that perhaps the selection process built in some partiality because it was behind closed doors. And we brought in a system that is no longer behind closed doors, and we've got an elected system that brings it out into the public, and now there's a concern, not that the public is not going to make good decisions, but rather that the public is going to be influenced by money. So Charlie, here's my concern. On the one hand, we have a study that says judges' decisions correlate to the money. So that would seem to suggest, at least imply, that the judges are being influenced. But we just talked to the judges, listened to the judges. The general experience here is that the judges perceive that it's more of a perception problem than a reality problem. Alicia now tells us that there was a perception problem back in Jacksonian time, essentially, started then, and that there's a perception problem now, and that part of it is that the money is not necessarily influencing, or I may have going to not put words in her mouth, but it sounds to me like the money's influencing the voters based on irrelevant criteria, not so much that it's influencing the judges. What do you think?
Well, I think that you've got a situation in which you do have data showing a perception of influence. But I think that the starting point for me is to say, if you are, let's assume you are as nefarious as you want to be, and you're out there with $1 million to put down on your candidate that you want to buy. I mean, let's just be as explicit and bald-faced as we can. You're not going to pick a candidate who is, inclined to vote the other way. I mean, that would be stupid. That would be bribery. That instead you are basically looking for someone who is ideologically aligned your way. And so in that sense, you are helping to elect a judge with all the perception problems from the public being in play, that you are assisting the judge who is predisposed to think the way you do anyway. Okay, now, does that mean there is no influence? I think that certainly anyone who suggests that there are more than a handful of judges who are explicitly influenced, who are told, okay, I got this $1,000, I guess that means I vote for him. I think that is unfair. I think that underserves just the oaths of office that judges take. Yes, it happens. It's called bribery, and they're criminals, and they go to jail. I mean, I think that's really what happens there. The concern is, frankly, at a subconscious level. I don't think it's 40-some-odd% of Texas judges thought that money did in fact influence judicial behavior in Texas. And I don't think that they were saying that that was because of corruption. I think that really the concern is, to what extent is it a kind of insurance? To what extent is there a subconscious impact of saying, there but for the grace of the Chamber of Commerce go I, and this thing that, okay, I was predisposed this way, but to some extent, is there a subconscious impact of knowing that it's but for the support I received from an organization that's really depending on a particular outcome, it wouldn't matter. I think still judges, as the judges here describe, they fight back against that. I mean, I think that they struggle against that. I do think that what we know is that there are certain things that we can't struggle against as effectively as others. I mean, I think Justice Benjamin was honest when he said he didn't think that he would be influenced by the kinds of support he received from the Massey Coal Company. But I think the public isn't fools to say you get $3 million of support without which you probably wouldn't be there, and it's very hard not to feel a slight debt of gratitude that might color your judgment subconsciously. And so, I mean, I think that it's overblown. The argument that judges are actually influenced is overblown. Is it possible it happens? If it does, it's at a subconscious level. But I don't think it's an irrational reaction on the public's part to worry a little bit about it.
So to the extent that we have a problem, to the extent that we now have elections of various sorts, we have some data that gives us some information about voting and about the election process and about money. Is there anything we can do about it to ameliorate the concerns we have? Char?
Oh, I get the fix this problem. Well, I guess the way I think about this, and going back to some of the facts in the original Caperton case, is that CEO Don Blankenship was toying with something that was very precious. What he was toying with was the rule of law. And I think he knew that. And he almost got away with it. You know, but for Justice Kennedy seeing things the way the Brennan Center and Ted Olson saw that case, it could have easily gone the other way. That was a nail biter of a case. And I think you either pay for this on the front end or you pay for it on the back end. I would encourage us to pay for it on the front end. So I think what we need is public financing for judicial races. We need it more in judicial races than for any other race that we have. I think we can tolerate a degree of bias and partisanship and, you know, venality in our executives and legislative branches. I don't think we want to tolerate that in the judiciary. And so if we're going to have privately funded elections, then we're going to get situations like Caperton. And I think the stakes are going to be higher and higher and higher, and the money that's spent in these judicial races is going to escalate, partially because that's the way the trend was already going, and Citizens United is likely to make that acceleration even faster. The other, if you don't pay for it on the front end, you pay for it on the back end. And I think the back end are going to be some really ugly recusal fights. And these, I think, are going to get even more contentious as the lawyers involved realize that they can be strategic in their political spending. And I could see a sort of nightmare scenario where the way that you get a really good judge to have to recuse themselves is to spend an enormous amount of independent spending that they cannot control around their election, which may color how that judge is seen by opposing counsel. And I think there's going to be some very weird behavior among strategic lawyers trying to get judges who are really good and really should be on these cases to recuse by spending money around them in a way that they cannot control.
I want to get back to the recusal issue in a minute, but you started talking about public financing. How do we get public financing? And how do we keep it when we do get it?
Yeah, I mean, one of the things that has been really distressing over the past couple of years is the loss of public financing in Wisconsin, in North Carolina. It is a very easy thing to be on the chopping block when there are budgetary constraints. But I think that we need to make a better pitch to legislatures and governors that to have a quality judiciary is worth the investment. And so I believed it when I was at the Brennan Center. I believe it more now. Giving judges an out from this privately funded way of electing people is worth the money in the first instance.
Alicia, I don't know whether the Brennan Center's looked at this, but if we're going to rely on the legislature and the governor to bring public financing in, then we're relying on the politicians to reject politics in judicial selection. Is that really an issue that's been happening? Either that the politics have brought it in or the politics have brought it out?
Well, I certainly think that there's an appetite among the public for public financing. There's a very sad loss in North Carolina last year. They had a very successful public financing system for a decade. It was widely utilized by judges in 2012. It was for appellate and Supreme Court judges. All of the candidates relied on the public financing system for that election, and it was very popular with the public, but it did not survive. It did not survive the legislature. So I think that there have been challenges legislatively to passing public financing. But I mean, all is not lost. West Virginia is oftentimes sort of brought out as a case study in what's gone wrong with judicial elections, and the Caperton case is a great example of that. but they, just this past year, made permanent a public financing system, and they had a candidate rely on it in this last election who won a seat on the Supreme Court, and I think probably wouldn't have been able to run a competitive election without being able to rely on public financing. And I agree with Chara. I think it's a really important element of addressing some of the problems and dysfunctions that we've seen in judicial elections, because it lets judges run competitive campaigns without needing to rely on special interest dollars. So it can remove some of the pressures that we've been talking about from judges.
Charlie, so if we can't get public financing and we still have money in the elections, is there any way we, especially post Citizens United, is there any way that we can put restrictions or regulate or do something with regard to that money in order to perhaps undermine the possible actual influence or the perception of influence?
I mean, in some ways, I defer to Chara, who's done more work on that than I think that from my vantage point, if you're basically going, I'm not among those who are convinced that public financing will help all that much, only because in the Caperton scenario, very little money went to the judge directly, that it was waged by third-party campaigns. That was where the millions of dollars went, and so you fund the judge properly and the third parties still get involved is my concern. In essence, I think you can look at systems of disclosure as a way to soften the blow, or you can think more seriously about moving away from systems of judicial election if you are really concerned about the impact of money. I mean, I think those are your choices, given that the First Amendment gets in the way of imposing all kinds of contribution and spending limits. That what you're left with is moving away to another system that doesn't depend on electing judges and funding it. But and I think the conundrum is that you look at popular support, and public is not a big fan of moving in states that have elections. People have been pounding the pavement for decades trying to get that to happen, and in jurisdictions that have contested elections, they're not prepared to move that direction. And I think what they're making a policy judgment that, yeah, we're not nuts about what elections will, about the corrosive influence of money on elections, but we prefer it to a system that is something else, because we like the ability to basically throw the bums out when we want. I think that's kind of the mindset.
So Charlie's just throwing this back to you a little bit, so you have public financing for the campaign, but you still have independent money coming in, and it's not restricted, you can't restrict it. So how does public financing help us?
Well, let me answer a slightly to the side question, which is, at least in the Caperton fact pattern, the $2.5 million that went through, and for the sake of the kids, was that the name of it? That group was organized as a 527, which meant that the money going through it was transparent. Hence, you could trace it back to Don Blankenship. And I think one of the other sort of disturbing trends, and I'd love to hear the judges' take on this, since they didn't want to know who their donors were, is the growth of dark money in federal and state elections. And by dark money, I mean the money that's going through 501c4s, which are social welfare organizations, and 501c6s, which are trade associations. And when money is funneled through one of these types of nonprofits, then it becomes totally unclear for the voting public who the original donor was. And I think this raises a particular problem in the judicial context, because if you don't know who is giving the money, I would imagine that donor will let the judge know, but he won't let the public know. And you won't be able to make your Caperton recusal motion because you won't know that the money came from the litigant on the other side.
So it sounds to me like on the disclosure issue, we've got double-edged sword, because on the one hand, if we keep it private from the judge, where the money's coming from, we're also keeping it private from the public, so that they can't know that this is out-of-state money, or that this is some particular interest group doing it. And so the public doesn't have as much information. We're trying to give them more information. And we're declining to give them the information upon which they can judge the information they're receiving. Or the other alternative is, we force disclosure, and that way the public knows the bias of the money, and the judge also knows the disclosure. Is Citizens United gonna let us do this?
It will. So the 5-4 part of Citizens United was the part that allowed corporations to spend an unlimited amount on political ads. The 8-1 part of Citizens United endorsed disclosure of that money. And so the courts, both in Citizens United and a subsequent case called Doe versus Reed, endorsed transparency around political spending.
So now we come to the part of, okay, so we have disclosures. Let's say we have disclosures. Now what? We've talked about recusal, and we have the issue.
Well, wait a minute, we don't have disclosure.
Well, we have, yeah.
That's right. No, we don't have them now.
Congress has to, that's
Right.
the problem.
We have the possibility of
Oh, yeah,
disclosures.
right.
Okay, we have the possibility, thank you. We have the possibility of disclosures. So then what do? So there's been a disclosure, we've talked about recusal. And so what I want to do is that we're going to introduce the notion of certainly recusal, as the judge himself or herself, removing from the case either because of a sense of actual bias or to avoid the perception of bias. We have the possibility of the parties raising the issue under a Caperton due process approach. We have the possibility of an ethical approach, that somehow this is unethical. And then we have the American Bar Association debate on Resolution 108. So we happen to have two key people from the American Bar Association debate. Funny how that happens. Tommy, from your point of view, what was going on?
What was going on is it is very difficult to have a uniform national rule that will apply to every state judge in every state.
I guess I should say, tell us what Resolution 108 was about, in case anyone doesn't know.
Well, it sort of was a corollary to Caperton. As most people know, the American Bar Association filed an amicus brief in Caperton in favor of the 5-4 result that came out of Caperton. As a result of that, the American Bar Association started looking at, can we do a uniform recusal / disqualification rule like we've got in either the canons of judicial ethics or the code of professional responsibility. This would have been probably in the canon, looking at the canons. There were several iterations of it. None were extremely satisfactory, particularly to the Conference of Chief Justices, with whom most of the negotiation occurred. And it became, at least in my mind, it became evident that you can't have a uniform rule that applies to every state, because every state's situation is so different in terms of elections versus partisan elections, nonpartisan elections. The amount of money, like I said, in New Hampshire, the exact same amount wouldn't make a whit of difference in California or New York. It's just very difficult to have that sort of, uniform rule on recusal. It's been kicked around. I think it's been kicked around so much we're about to flog the deceased equine.
Judge Smith, what was your role in the 108 debate?
Well, you have to understand that the ABA passed a Resolution 107. And in Resolution 107, it says this is a problem, but each state has a different system, and so we ought to leave it to those states to do something about it. And then it said, and not only that, but the Standing Committee on Ethic and Professional Responsibility and the Standing Committee on Professional Discipline should consider what amendments, and this is the important language, if any, should be made to the ABA Model Code of Judicial Conduct or to the ABA Model Rules of Professional Conduct, the judges or the lawyers, to provide necessary additional guidance to the states. Well, so the committees got together, and the first idea of their rule was to give both the judges and the lawyers some very tough ethical standards. The lawyers fought pretty well, and I guess the judges didn't say too much, because the next amendment was that the judges would bear the ethical responsibility for these types of situations. So I was the chair of the Appellate Judges Conference, and the Appellate Judges Conference stood up and said to the joint committees, now come on, what is there we really must do ethically? Ethically. Now, there's no judge who doesn't believe that you need to have a very fair system, one that should be, with me, I think a disclosure system is good. None that didn't believe in that. But whether it should be something that charges the judge's ethics, how far do you go? And the judges said, we don't have any trouble with the ethics being something judges are charged with if they know about it and if they control it. But if you're gonna go to 527 committee, if you're gonna go to other types of ways to do it, it seems to me that's beyond what judges ought to do. That in fact, judges ought to do what's important for them to control themselves, that they know about. That's one thing for ethics. But after that, it ought to be a procedural rule. In other words, judges shouldn't be out scouring the bushes, doing their own discovery, using courthouse discovery techniques or whatever else it is to come up with, and therefore what we ought to have is the lawyers ought to bring it to the judge in those situations under a procedural rule, and at that point the judge could make an appropriate determination, not getting the evidence, but reviewing the evidence and making a decision. And so we fought the joint committees, and then the Conference of Chief Judges came in and said, both of you forget it. We want to think about it. Because, in fact, we're selling it to the Conference of Chief Judges. They're the ones who are going to propose it. And if the ABA can propose whatever they want, but if the Conference of Chief Judges doesn't accept it, it's not going anyplace.
The conference of Chief Justice is not an ABA organization.
Not an ABA organization.
They are independent of the ABA.
So when they said,
by their choice.
When they said, cool it, we don't want any of that, stop it, both of you. So it stopped. And when it stopped, then they came out with a new resolution, and the new resolution is about where 107 is. It says each state has their own thing, they've got to develop these, and we're going to let the states develop them. So that's the new resolution 8 from the Conference of Chief Justices. So that's kind of where it went.
So let's say we had some kind of guidelines in that regard. Are we going to be seeing then this flood of recusal motions? Are we going to get an entirely new approach to recusal motions?
Well, that's the way it came up in Caperton. It was a procedural idea. I think there will be some flood, but I'm not sure how much flood. And then after that, I'm not sure how much it isn't something the judge can't deal with as he does other motions of similar type things, like discovery, like other little things that come up. I mean, we already can motion to recuse judges for other things that happen, and they have to deal with those. This would just be one extra thing that they would have to deal with.
What would be the standard of review? Upon appeal, What would be the standard of review?
Well, again, we're saying the states will determine that. We're not taking a general view. We're saying this is 107. Each state's gonna make their own. Some states are gonna say it's an abuse of discretion. Some states are gonna say de novo. I would only say I've dealt with one abuse of discretion. That was in Prop 8. If you all remember Prop 8, you'll remember there was a specific judge who ruled on the gay marriage issue. And so after all the ruling was up and it was in our court, then he comes out and finally suggests that he might be homosexual himself. So at that point, should he have recused, should he have not have recused? And we have in the federal court an abuse of discretion review. And it was pretty easy for us. In fact, I wrote the opinion, pretty easy for us. If it's an abuse of discretion, I look at it and I determine what to do. And in that particular situation, it was even better because he didn't make the decision. Another judge, because he'd already retired from the bench and another judge had got the thing. When the motion was finally given to the other judge, he said, phooey, there was no problem there. And then we had to decide where it's an abuse. We said, it isn't an abuse, it's fine. But de novo abuse of discretion is important. Not only that, but there's another important part. How soon? The motions now for motion for disqualification are seen when the case is over. In other words, it isn't immediate. It's something we do in the general procedure of all of our cases. Just like a discovery motion, just like an evidence motion. It goes to the end and goes up. Why? Because in the whole, it doesn't make a whole heck of a lot of difference, quote unquote. And so therefore we get it to the end. Because what do we do at the end? Harmless error review. So we push it off to the end to make sure that that's when it's reviewed. Now there's some idea, some states are gonna have to decide this. Should you do it immediate? Should it go to a colleague? Should it go to an appellate group? What should be the result? How should you deal with it? There's nothing said how you should deal with it, only that that's the way we're gonna address it.
So I'm gonna give the panelists an opportunity to just make some closing comments and we'll take some questions. But let me go back to where we started. We have a study that says that money in judicial campaigns correlates, money from business interest groups correlates to pro-business decisions at the Supreme Court level. So that raised all these various questions about money, elections, disclosures, disqualification, and we still have the issue underlying all of this is there actual bias? Are judges really having a self-interest bias that's creeping into their decision-making such that they are no longer impartial because they have a horse in the race, they have their own personal interest? Or are we more concerned about the perception of bias that exists in the public because we know that the public does believe that money influences the judges? Alicia, any closing thoughts from your experience at the Brennan Center?
Sure. Well, I'd like to go back to this question of perception and public confidence in the courts and how that impacts, in particular, the debate around reforms to recusal rules. We've done some polling on this issue, and I think there's an overwhelming appetite among the public for stronger recusal rules. Most states don't have any rules at all regarding when judges need to step aside from cases when candidates have contributed money to get them elected. And even fewer have rules regarding independent expenditures, which, as we're seeing, is kind of the new frontier in judicial elections. Just this past year, we did some polling with Justice at Stake and found that 87% of voters thought that campaign contributions or independent expenditures were having at least some impact on judges' decisions. And over 90% thought that judges should be stepping aside from cases where litigants had been contributing to their campaigns or spending money independently to get them elected. And so I think that we need to, I think from that perspective, putting aside the question of actual bias, I think that's a separate issue and something it's one, hard to get into an individual judge's mind, and two, I think sometimes judges, just as any human being, there can be subtle ways that we may not even be conscious of that our decisions may be impacted by contributions or other relationships to litigants. But I mean, putting all of that aside, I think there's a separate and in some ways even more important question of, is our public trusting that our courts are fair and impartial? And I think the role of money that we're seeing in elections, the weak recusal rules that we're seeing in states is drawing that into question.
Charlie, parting comments?
I mean, I think there's, at the base of the conversation, there is a paradox here, which is, on the one hand, we want judges who are not only impartial, but who believe to their core that they are impartial. We want judges who take the oath seriously. We want judges who say, you can give me money if you want, it's not going to affect me. You can, and disqualification implies a kind of failure in some ways, at some level. If you're to the extent that you're saying, no, I have to avoid an appearance of impropriety, I'm not going to concede that I've created an appearance of impropriety here, because I am working hard to maintain my impartiality across the board. And that creates a challenge, because from the public's perspective, the public is much more dubious about the impact that money may have on judges, or that other things. In other words, I think one place where it came to the fore for me with disqualification was, if you talk to an average citizen about the normal state of affairs with disqualification, which is you believe that a judge is too biased to sit, and the procedure is, who do you ask whether they're too biased to sit? The judge who's too biased to sit. And you say, well, Judge, are you too biased? No, I'm not too biased to sit. Well, I guess that ends that. And from a judge's standpoint, most disqualifications are strategic. They're being pursued by people who are making borderline frivolous arguments, and the idea that we're going to stop things dead in their tracks to deal with those people is goofy. But the flip side of it is that for people who are suspicious, the idea that you're going to ask judges to grade their own papers is a little odd. And so I think that what you have this paradox where you want judges to believe that they're impartial and to act on that belief, at the same time as we want them to be mindful of a perception of the public that's very much more skeptical and is very much in tension with what we want judges to be. And so that's, I think, the push and pull that we're seeing here.
Before I ask you, Judge Daughtry, Charlie's brought up this factor of asking the very judge who you believe is biased, to make judgment on his or her own bias. But there's been some efforts at times, haven't there, where there's been essentially a peremptory challenge to judges. Are you familiar with any systems in which there essentially has been, you get to strike one judge?
Yeah, and the other side of this question, of course, is that we've all taken an oath that we will handle what comes in front of us, and so there have been cases that I've sat on that I wish somebody would file a motion. Because I sure can't walk off. Well, that was before I took senior status. I actually can walk off.
I mean, there's some cases, even though you could do it fairly impartially, you just as soon not. Yeah.
Well, the first thing I did when I took senior status was notify Cincinnati that I didn't want any more death penalty cases. So I had my fill of those. But yes, there is the problem that judges not only, I can understand how judges think, well, I can handle this fairly. But there's also this responsibility to not throw it off on somebody else. I mean, you're supposed to do your work, and I think that plays some role in it. But I do think the point that Charlie just made is the conundrum is a fairly good question, and I'm glad I've never been faced with it, because I don't know the answer. Maybe somebody else here is. Do you know the answer?
No, I don't know the answer. I'm not saying that, but I truly do believe that in this duty to sit, I mean, there's a duty for judges to sit. That's as much our ethical duty as any duty we have. We have a duty to sit on every case that comes. Now, the other problem that you have when you bring up this political stuff, which has not really been put out here, is that sometimes in the tough races, you disqualify yourself from the tough case because then you don't have to take the crap over the issue. I mean, that happens in Idaho half the time, sad to say. I mean, there are a lot of judges who say, I'm gonna DQ on that case, and that's the tough case.
Yeah.
That's the tough case, but they DQ because they say they have something, and that prolongs their way to stay in office by not having made a decision that people can get excited about. So there's the duty to sit and not to disqualify in the tough case. And to put that in perspective to what we have to do, that's the only thing that I would say to Charlie that you have to think about. The whole of this is we have to police our own. That's the one thing Charlie said I really appreciate. We've got to stand up and start policing our own. But we got two duties here. One is to sit and one's to get off when we shouldn't sit. And the ethics of when we get off when we don't sit has to be something we control, that we have control over. After that, give us the issues, put it before us, and let us decide what we need to do. Because we do have the duty nonetheless to sit.
Charlie.
So let me add in one more wrinkle. In the original Caperton case, the $3 million came from an individual. In future cases, post-Citizens United, that opens the possibility that the money will come from corporations, from multinational corporations, from enormously wealthy corporations. And so one of the things that I worry about with the rise of dark money is that negative political ad that's trashing your local judge, that could be paid for with your 401k. And so I think we have to be much more serious and engaged as shareholders and as citizens. And so I think we need to demand more of our legislatures in terms of mandating disclosure, whether that's the Congress or our state legislatures, because the nightmare scenario is that you end up funding elections that do not represent your own self-interest.
Thank you. Tommy, party comments?
Well, the ABA has been very, I think, spectacularly successful in its model rules of professional conduct, which have virtually been adopted verbatim in just about every state. They've also been, I think, fairly successful in the canons of judicial ethics, with a singular exception. And that happens to be in Rule 2.11, which talks about disqualification, where basically it says a judge should disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned. And then it gives you a list. Number 4 on the list happens to be the judge knows or learns by means of a timely motion that the party or a party's lawyer or the law firm of a party's lawyer has within the previous however many years made contributions to the judge's campaign in amount that is insert amount, greater than insert amount, you know, or is reasonable and appropriate for an individual or an entity. I mean, that's sort of the menu of options. Not a single state has adopted that. Zero, absolutely zero. It's been in there for 20 years, and that particular provision has not been adopted. It's pretty evident to me that ain't what we need. Because if nobody's going to adopt it, we need to come up with something else. And it's a very thorny issue. The judge indicated the kind of the development of a recusal / disqualification standard has not been able to get through the ABA because of the differing state standards. It's a tough issue, and I think it's made tougher by what Chera said, the dark money. Interestingly enough, you know, as I pointed out in Caperton, I was fortunate enough to sign the ABA's amicus brief, so I actually had to dig in and figure out the exact facts of Caperton. The ruling that was made was in favor of Massey Coal Company, not in favor of Don Blankenship. Don Blankenship happened to be the president of Massey Coal Company, but he wasn't personally, quote unquote, involved in the results of that decision. The company he was president of, which is a very big company, was. He also didn't give the money to the justice's campaign. In fact, what he did was give it to another group that was opposing the sitting justice that he was running against. So you had to connect several dots to get there. Yet the Supreme Court, when it got there, didn't have any problem connecting those dots. In an interesting sort of way, I think you can go back, sort of the genesis of all of this, I really think, is Republican Party of Minnesota versus White. Yep. And in my own probably perverted way, I think what the Supreme Court was saying in White was, election of judges is a bad thing, but if you're gonna do it, it's gotta be a free-for-all. And I really think that the Supreme Court, in deciding that case, thought that they were gonna make judicial elections so ugly that everybody would run from them. And they didn't. I think they did the former, but the latter didn't happen. And so I think that's sort of where we are.
It was interesting that Sandra Day O'Connor was the proponent of, you know, go to your legislatures and get them to do away with elections. And I think everybody here who knows squat knows that getting legislatures to do away with elections is like, you know, in your dreams. And I was surprised at that because she was a member of the Arizona legislature before she went on the bench, and it seems to me she should have had a better pragmatic approach than that. I mean, that was theoretical to the max, and I wondered if that's not one of those votes that she regretted. As I said earlier today, most of us who go on the bench know that we are sacrificing our unfettered First Amendment rights, and we make that sacrifice gladly. Either that or you don't go on the bench in the first place. And and I think most of us embrace that. And to say that same standard doesn't apply to those who run against us, for example, but candidates who are not incumbents, simply makes no sense at all to me. I was in total disbelief when I read that opinion. Beware of a right-wing judge who decides to speak up for the First Amendment. It may not be the thing that you would.
Judge Smith, final comment.
I'm not going there, Judge.
Okay.
I only have one final comment, I emphasize what Charlie said. There was an attorney general in Idaho who wanted to run for office, and we have nonpartisan elections. And so when he announced he wanted to run for the Supreme Court, he announced it at the Republican Lincoln Day event. In other words, he came to the event he'd always come and spoken at, and he said, I'm running for the Supreme Court, and I'm your candidate. And of course, all the Republicans were there, and they were pretty excited about that. At the time, I was the Republican chairman of the state. And I believed in our nonpartisan elections. Thinking about it after I've heard all I've heard today. But I believed in our nonpartisan elections. And so I got right up in the meeting and I said, Attorney General, I'm glad you're running for the Supreme Court, but we don't have a Republican candidate. This is a nonpartisan election. And I'm voting for. And I named his opponent. Now, I did that not because I really wanted his opponent. But because, and I only give you that story because I think judges can do a lot in this themselves. I think we can say and do things that we, as long as the canons will allow us, which can do things where there are situations where we can speak up. There was a situation in our state where a certain judge ran against another, and the third-party contributions in that particular election were pretty wild, and they started going on things that really had nothing to do with what the election was about. And I really believe that if that judge had stood up and said, I do not like that, and I'm not going for that, it would have been a good thing. Now, I'll be fair, I said, you can't lose, because those who are over there are still gonna like you, and yet you're gonna bring in a lot of those who don't. But I think we've gotta do things like that. Because of the whole, it's tough to know exactly where this is gonna go. And it's like I said once before, we can get all as excited as we want about there won't be elective judges, there won't be partisan judgeships, there won't be any of that, but we're not gonna win that, boys. We gotta do best with what we got and do it as best we can. And I think we have to stand up and fight for what is real if we're gonna be judges, or if we're gonna be candidates to be judges, and do it right. And that's why I think that. And this last part is, I think you can't emphasize our duty to sit. I think you can't emphasize that enough. And sometimes we lose that in the whole.
Thank you. We have just a few minutes for questions, but Professor?
Sure, I just had a question. I think a lot of the judges have discussed that maybe it's not the actual bias we should be concerned about, but the perception of bias. But at the same time, you talk about the duty to sit, and how some judges, in order to avoid the trouble that could come with an honest ruling, just prefer to disqualify themselves. But isn't that, I mean, I understand that that's maybe a lesser of the evils of voting in a specific way that you would disagree with because of the money, but isn't that still the fear of the ad, or the fear of the opposition money, or something explicitly driving the judicial behavior?
No question. And I don't know that it's a lesser error either. No question.
So then it would be kind of an instance of actual bias that wasn't the whatever, voting in a particular way, just refusing to vote.
Other questions?
I just had a question. The idea that there would be a flood of recusal motions is an interesting one to me, especially since I spend a lot of time looking at repeat players in the legal system. I would think that, you know, attorneys that are going to go before that judge again and again would not want to file a recusal motion, because it's going to risk making the judge mad that they're getting all these, you know, essentially nuisance motions. And so, do you think that the flood is going to come from people who are like one-shot attorneys that don't, you know, that aren't going to spend a lot of time in court? Like, where is this flood going to come from? Because I would think attorneys that are going to go again and again to the same court, especially in a, you know, a state where there's a small bench, you're not going to do that. That's just me.
In fairness, I don't think anybody on the panel said quite that there would be. It was I that posed the question of whether there would be. Tommy, what's your take?
Well, like I said, I've only filed one recusal motion in my career, which has been quite a while now, over 30 years. And I think, at least on mine, I think I had pretty good grounds that, you know, my opposing counsel was representing the judge in his indictment. I haven't seen any flood of recusal motions. Actually, what I've seen more often than recusal motions are sua sponte recusals. And some of that, I think, as the judges have said, are just, oh, get away from me, don't bring me that case. And it could be because it's the issue involved, but more often when I've seen those recusal motions, it's been, this is a really complicated case, and I've already got, 140% of what I ought to have as a docket, and they just took away my law clerk because of the budget cuts, and I just don't have time to fool with it, so I'm recusing myself. I had a case that was transferred from Jefferson County to Tuscaloosa County several years ago. There are 4 judges that sit in Tuscaloosa County. In one day, all 4 of them recused themselves when that case was transferred. So I was sitting there, and the Supreme Court was gonna have to appoint a judge to take that case.
I think your point's well taken.
Yeah.
And it makes sense.
I do think, however, that there are cases out there where we shake our heads and say, why wasn't there a motion to disqualify on the front end? And it is because the lawyer doesn't want to irritate the judge, and knows he's dealing with the kind of judge who would say, you're saying that I'm biased in some, yeah, that happens.
So we're really out of time for questions. To the extent that the panelists remain around, you might come up here. I want to leave with just a couple of comments. I have a bias. I was an appeals court judge. I guess I should also disclose that I was merit selected and retention retained. My experience with the bench in Colorado is that the judges I knew, the judges I know, they were dedicated public servants. Unfortunately, the population doesn't quite get that, and there's far too many people suggesting that judges are other than public servants, that somehow they are self-interested politicians. I think that's part of the problem, is that perception, and that the judges, as Judge Smith maybe has implied, the judges need to get out, and they need to be out among the public, and the public needs to meet them, and they need to discover that these are people of special character. The most of our judges just want to get it right. They just want to get it right. They want to be fair to both parties, and they want to do justice. That's my experience. That's my personal experience. Part of the problem is that judges, not a problem, the reality is judges are human, and our voters are human, and our population is human, and so they recognize that there are human impulses and human pressures. What they need to realize is that most people who are judges are humans with a very special character. They're humans who are dedicated to our country, they're dedicated to the rule of law, and they're dedicated to the system of the justice system and to keeping it fair and impartial. Perhaps it's time, as has been alluded, that the judges need to participate more to increase confidence in just who they are rather than who people perceive them to be. And with that, I'll say thank you for your attention.
Could I make one other slight comment? I know there are a lot of you in here right now who are scholars and non-lawyers, but for the lawyers in the room, there's also an ethical obligation when you see a judge who's been unfairly attacked, whether during an election or any other time. There's an ethical duty on the lawyers to stand up for the judges, because the judges generally under the Code of Judicial Conduct can't reply for themselves. They can't stand up for themselves. So there is an obligation on your part to defend us when we deserve to be defended.
Please join me in thanking this.